President Donald Trump is on a winning streak. At least that's what it appears, with recent court victories in the Ninth Circuit, the Seventh Circuit, and 3 indictments on people who have been on his political enemies list. It appears as though the Trump administration is going full steam ahead. Now, I'm going to tell you folks, I did not want to go back here. I did not want to go back to politics and Donald Trump. You may have noticed that I have been moving away to other stories on this pod because, quite frankly, there are other things happening in America. But this is just too much to ignore, too much going on. And so I'm here to break it all down for you. And hi, I'm Alyse Adamson, and welcome to another episode of At Least You Heard It Here. And to help me break all of this down is Greg Rosen. He's a former chief in the U.S. Attorney's Office here in the District of Columbia for federal major crimes and the Capital Siege section. He is now a partner at a private law firm, but most importantly, he is a good friend of mine and to the pod. So welcome again, Greg. Thank you for being here today.
Very happy to be here, Alyse.
So Greg, I wanted you to come join the pod for your just infinite wisdom. You've been featured on CBS. I'm just going to give you a little plug. NBC, the major news outlets have now recognized what an authoritative legal voice you are. So of course I had to get territorial and bring you back to the pod. But there's like a lot going on right now with the Trump administration. And, what people are seeing, or what the headlines are, is that Trump is on a winning streak, right? Like at the time of this recording, he's just had a consequential ruling out of the Ninth Circuit, and that is the appellate court that is responsible for cases coming out of California and some other Pacific West states, such as Oregon, which is where the Portland litigation is happening. And he's also secured 3 indictments against James Comey, Letitia James, and John Bolton. And these are people that we know he was very upset with and had said he was going to be seeking retribution. And so all of these things are happening, and myself and a lot of other folks are sitting back and thinking, how and why? So I know that's a lot to just throw at you. So why don't we just start with these indictments? So 3 people have now been charged by a federal grand jury. They're facing felony criminal counts, and they're 3 people that were very outspoken critics of Donald Trump. What is your take on all of this?
I mean, look, I've said it before, it's stunning. It's stunning on so many different levels. I think it would be fair to say, at least from my perspective, right, as prosecutors, when we were in that job, almost more important than the results of obtaining justice were the actual process of obtaining justice, right? Due process is going to be everything. And I would say it's actually a defining feature of American democracy. And what we are seeing is a department and an executive branch that seems hell-bent on identifying targets and then pursuing cases based upon those initial identifications. So stepping back, right, concept of the rule of law, this is not particularly great for the developments of the rule of law in the United States. Each case, of course, is different, and so I'm happy to kind of walk through my thoughts on each of the cases. But I think DOJ is going to have a very long road to hoe in terms of getting results. Yeah,
let's take these cases kind of one by one. I do want to make a quick point, and let's start with Letitia James first, because this is in service of my point. What you just said is, this is Justice Department that kind of fixated on a target and then found crimes. Now, isn't there a fair critique or criticism of Letitia James? And for those of you who don't know, she's the Attorney General in New York. But isn't it true that she ran on a platform of bringing Donald Trump to justice? This was before she was even in office. We didn't really know what charges. And she was very vocal about being elected and going after him. Isn't that kind of the same thing, kind of a target focus and then finding the crime?
So look, right, as a lawyer, I speak in nuance, right? The traditional lawyer, we always say, it depends. That's the lawyer answer. And unfortunately, that's going to somewhat come out right now too. I think they are similar, and they're also not similar. I think they're similar insofar as far as I understood, I didn't really follow her campaign that much, but she did seem to run on not charging Donald Trump, but investigating Donald Trump.
Bringing down corruption.
Bringing down corruption. And so that type of rhetoric, though, whether it's on the left, the right, in between, that is exactly why it's so corrosive to the criminal justice system. Talking about identifying targets and then actually pursuing those targets is very dangerous, right? And so I do view the rhetoric as both problematic and kind of similar and in similar buckets. The difference, of course, is the end result. I mean, Letitia James, as an outside observer, investigated that almost to a point that people thought, it was almost too much. But, the amount of sort of leaves that were being overturned and everything investigated in terms of the specific, allegations of the Trump organization dealings. So where it becomes a huge difference, though, is how these investigations develop, right? There is a distinct difference, as we'll talk about with John Bolton, between an investigation that is essentially stovepipe, where the result is guaranteed from the beginning, versus something that develops organically. So in the case of John Bolton, for example, that was an ongoing investigation that related to a leak that dealt with a foreign nation, right? In the case of Letitia James, the reason why the Trump organization was initially investigated, ignoring the rhetoric and putting that to the side, was because Michael Cohen spoke to Congress under oath about the inflation of those deals. And so that is what triggered the investigation in and of itself. Those two things are drastically different. So you can critique Letitia James as a politician, but as Attorney General, she did what a lot of attorney generals or a lot of prosecutors would have done, which is obtain an allegation, discern exactly what it means, investigate further, and then decide what comes next. And that's, I think, critically different from what we saw in the Justice Department in the last few weeks, which was, we have a target, we need to identify the target, just find me the crime.
So for folks that don't know, Letitia James has recently been indicted for mortgage fraud. And the allegation is really simple, right? That she took out a mortgage for another property, a secondary property, and said, this is going to be my secondary residence. It's not going to be an investment property. And the allegation, and these are all allegations because she's only been charged, is that she indeed rented it out instead. She actually filed some disclosure paperwork indicating she had received rental money from that property, and that she had sworn that it was not going to be used as a rental. So it's a very straightforward theory, but it seems like the case is a lot more complicated than that. So can you add any color to this or any thoughts? Because the indictment, I looked at it, it seems a bit paltry, like lacking. There's not a lot of words in there. There's not a lot of explanation, which you would expect in a case like this.
No, you're 100% right. So the theory itself is simple. The facts are not. And in fact, the facts are somewhat inverted, because the reality is as if you believe media reporting, which again, we'll see when things go to trial, but there's some reason to believe that she was also not renting it out, and then she had, either through some mechanism, but that a family member that she had purchased the property for was staying in Norfolk in the house. The reality is, you can mine DOJ's record. A lot of these records are public, right, through PACER and through ECF. I would venture to say, yes, right. I would be shocked to find a similarly situated mortgage fraud case where the allegation is a loss of, and I say only, it's only in context of a federal case, $18,000 from the department pursuing one count, essentially, of mortgage fraud coupled with the false statements in a case like this. In other words, for your viewers, I don't think there's going to be a similarly situated case across the United States that fits this fact pattern, which
and why?
Because this is not something the department particularly pursues, right? So when it comes to mortgage fraud, first of all, as you know, right, when you go to sign a document, whether you're doing a lease or whether you're, buying a house and going through a mortgage company and dealing with the lender, these documents they're written by lawyers, they're written by lenders, they're enormous. And so when it comes to prosecuting cases that rise and fall solely on intent, that you intended to deceive, having a mistake or an error, or perhaps even a intentional error in a 100, 200, 1,000-page document is not going to be the be-all, end-all in proving that beyond a reasonable doubt. And so those cases require significant investigation in terms of determining what the person was thinking, what their state of mind was. Were they intending, did they make a mistake? Was it an accident? Or were they intending to actually deceive the bank? And so the documents themselves don't actually speak for themselves. And so when it comes to these types of cases, they need to be a robust dive. And investigations take time, they take money, they take prosecutors, they take investigators like FBI agents. And so as a result, DOJ is going to prioritize cases that actually matter, where the loss is severe, where somebody was harmed in the process, where it is, hundreds of thousands, if not millions of dollars of someone bilking the taxpayers of the United States. Something as paltry as $18,000 in this context, to be clear, I'm not saying that it couldn't be a crime, but I am saying that this is not something that the department would ever meaningfully pursue absent some other investigation or some other ancillary criminal probe.
Right. Well, let's move into Comey and talk about petty cases, because that is also my understanding is the framing of James Comey's case, which if you thought that Letitia James' indictment was kind of sparse, James Comey's indictment is almost non-existent. Like, I looked at that and I couldn't believe I was seeing an indictment from EDVA. That is the Eastern District of Virginia. That is who is prosecuting the case, and we'll talk about who's leading that office in a second. But it was very short. I wasn't even clear exactly what the theory is. I mean, I would probably ask to file a bill of particulars. That is some legal weeds, but it's basically, I need to be put on notice as a defendant exactly what you're charging me with. What are your thoughts, Greg? I mean, again, I saw this and I'm like, okay, you got the indictment. They say you can indict a ham sandwich because the standard for a grand jury indictment is probable cause. That is way lower than beyond a reasonable doubt, which you have to prove at trial. It's more likely than not. And there is no defense in the grand jury. It is all government theory. And so there has to have been some evidence to get this indictment. I'm going to say there has to have been some evidence, but it doesn't need to be the strongest, a case-winning evidence. And with this indictment, I don't even know what that evidence is. That was my thinking when I saw this, but what was your reaction?
I think it's a travesty. The department, so stepping back for your viewers, and you know this because we both did this, when we brought a case to the grand jury, we didn't do so under the guise of let's just get it across the line so that we can then pursue, additional investigative leads. We wanted to prove that we could prove the case beyond a reasonable doubt. That is the prevailing standard that is required by the Justice Manual, by the department's, principles of federal prosecution. And this has been 50 years, in the making. We know how to do the job. And so the idea that you would sort of get a case across the line just to, quote, get the indictment so you could prove some sort of, we can do it, is, I've used this word before, also got made fun of for using this word before, anathema to our principles of justice. So the other thing that I had a reaction to was the bare bones indictment, right? Cases that are so high profile like that are usually done through what's called a speaking indictment, right? So it's a document that lays out, like we saw with John Bolton, the specific investigative steps, the meat and potatoes, so to speak, of the investigation and why you can prove this case not only by probable cause, but beyond a reasonable doubt. None of that happened here. And so not knowing really much about the investigative process, what that tells me in my training and experience is that this was rushed, that this was something that they wanted to, there was a statute of limitations that was coming in days.
And statute of limitations means the time a prosecutor has to bring the case. If they didn't bring the case within that time frame, they couldn't bring it at all, right?
Yep. And so they needed to get this across the line and get this thing presented to a grand jury. So that's one reaction that I had. The other reaction that I think raised serious questions is, again, this case, just like Miss James's case, rises and falls on intent. Because not every misstatement, not every error is in fact a crime. And so when you're dealing with false statements or obstruction of justice, you have to prove what they call corrupt intent, that there was some sort of malicious intent to lie or deceive or sort of not tell the truth, not simply that they said the wrong thing. And so then it comes down to what was presented in the grand jury. And so you and I both know that our training is that not only do we present a fulsome story of the crime in the grand jury and to the grand jurors, but that we are required to present evidence that could materially negate a finding of probable cause. It's built into, again, the Justice Manual, which is this, you can consider it this like talismanic book on how to be a prosecutor for, assistant United States attorneys. And it's publicly available. That transparency is pretty important. And so there is a legal debate as to whether or not you actually have to put in and what level of exculpatory information you have to put into the grand jury. But the reality is no prosecutor, as a matter of ethics, would ever present a case without giving the full, complete story, including things that don't help our case. And so if, for example, there is an IG report that concludes that there wasn't a lie or concludes that there's more gloss to it, and those underlying facts were not presented, it raises very serious ethical and legal questions as to whether or not the grand jury was misled in the process.
Yeah, and he's basically being indicted for allegedly lying to Congress. And this is why I said at the outset, like, they really need to beef this up. Like, what exactly was a lie? They mention a potential lie. This is all about information being leaked to the media, but it's all very confusing. And as you insinuated, there has been a report essentially kind of exonerating James Comey of this. So very interesting to see how this will play out. His counsel has already filed to have this entire is filing to have this case dismissed, and I think has just filed challenging the appointment of the current acting U.S. attorney, or interim, or I don't even know what her status is, quite frankly, because she was installed so quickly, Lindsay Halligan, who was put in place mere days before Comey was indicted after the other U.S. attorney, Eric Siebert. The reporting said he was not going to indict because the evidence didn't support it. Of course, that's just what the reporting said. He ultimately resigned. Donald Trump said he'd be fired. Who knows? Lindsay Halligan, now, of course, President Trump has the right to appoint whoever he wants, but it's important to note Lindsay Halligan has no prosecutorial experience whatsoever. She was a partner at an insurance law firm, and she is most notably one of Donald Trump's personal lawyers. And now she is heading one of the most elite offices, U.S. attorney's offices in the country. So she's installed, and then all of these indictments drop. And, I know I'm talking to someone who understands this, but even the optics, just the optics alone, you're putting someone into an office who has never done this job, and mere days later, she personally, it was her name on the indictment, indicts Comey, and it's, as you said, bare bones indictment. What other conclusions can one draw given the timeline of events, right?
If it looks like a duck and it quacks like a duck. So, look, I actually want to push back a little bit on one thing you just said, which is
Okay.
I think that the president does have the authority to nominate whoever he wants. But underlying, and it typically is good that you have someone who has wherewithal and knows how to do the job, right? Which is, I think, the thing you're pointing out for Miss Halligan, which is she's never been a prosecutor before. That's not in and of itself disqualifying, but it raises serious questions as to why this person was nominated in the first place. That said, one thing that, as I read the motion to essentially get rid of the case for the purposes of the appointments clause, which is the specific mechanism by which she was appointed and whether that was illegal, one underlying theme here is, yes, the president has the right to nominate who he wants, but there's a process by which the Senate can advise and consent to who is chosen. And it has to do with, the nuances of the Constitution, principal officers, inferior officers, the mechanism of appointment. And without going too deep in the weeds on that, the most important takeaway is, just like a criminal trial and a criminal defendant, there is due process to the actual appointment process too. And so the underlying theme here is that the administration is perceived, whether it's right or wrong, is perceived as abusing the appointment process entirely to get what they want. And in every single field that I'm sure you've talked about and that we've tackled and we've seen over the last 10, 11 months, there's a spirit of the law that does not appear to be followed.
I was going to ask high level. I mean, I want to just touch on John Bolton very quickly because we have a lot to get to about whether or not you see these indictments as wins. But John Bolton was a former national security advisor to Donald Trump in his first term. He only served like 17 months. He had a lot of tension and conflict with President Trump. Then became an outspoken critic, of the Trump administration published a book, and there was a lot of back and forth during that book publishing about whether or not there was classified information contained in that book. And actually, DOJ at the time, this was Trump's DOJ, moved for an injunction. They wanted the court to essentially block further publication of this book and also like take the books off the shelf because of the potential for classified. You remember this? And my read on that was, of course, these are all allegations. Mr. Bolton is going to have his day in court. And he can defend. There are defenses to this. I mean, just classified markings alone does not mean it was classified. With respect to Bolton, I was looking at his indictment and I'm like, I know the president doesn't like you, and I know the president would like to see you in jail, but this seems a little factually distinct, and I'm not sure you have the same claims, but I want to get your opinion on that.
Yeah, so I mean, as with everything, it's nuanced. I agree with you, though, that I think this case is different than the other two cases. But one of the problems, and I think you're sort of insinuating or sort of getting to at its core, is when you cannot distinguish between legitimate and illegitimate prosecutions, the whole ballgame is over. And so there are some serious concerns here about how the political environment interplayed with the department's actual investigation. So at a high level, I agree with you. This is a far more buttoned up indictment. I mean, it reads like an actual real indictment, a big boy indictment. You would expect it to have sort of certain facts. It's it is a speaking indictment. It has very sort of detailed, granular facts that lays out the investigative steps. And to me, it reads as if DOJ is trying to scream, "See, we did this right." And I do think that there is some serious conduct that has been identified, though, as you point out, there are aspects of it that raise questions for a defense, to include what type of classified information was actually obtained. Why was this information not known during the pre-publication review process of the book? Because this is something that was sort of, center mass of the FBI and the department's initial complaints in 2019 and 2020. And so it does raise questions about what the FBI knew way back when and why they didn't act on it until recently, and whether that was itself political. But I will also say that though this case is not as strong on the vindictive selective prosecution fronts as the other two, there is still an aspect to this that raises serious concerns about how political leadership within the department guided the investigation. The indictment itself is signed by the acting U.S. Attorney Kelly Hayes, who has been in the department for a very long time, very well known as a straight shooter. So my initial reaction is this is not the same as those other two indictments, but there are still defenses and there are still concerns about the political interplay here. I will also say that with respect to the charges themselves and whether or not the juice is worth the squeeze, I've heard a lot of people try to compare this case to, let's say, President Trump's case in Mar-a-Lago. And I do think it's very hard to compare any one case from another, given the specificity of facts, and also the fact that, on one hand, it was really bad. He was alleged to have possessed at Mar-a-Lago classified information, but he also was the former president of the United States. So it sort of kind of cuts both ways. The same thing with respect to John Bolton. It's obviously very serious that you possess unauthorized classified information. On the other hand, it was presented to two family members, and otherwise the reason it was disseminated was because of this foreign actor hacking. Coupled with this screams for me, I mean, I don't see a huge difference between what, for example, General Petraeus, who had a similar case of this and ended up resolving it via a misdemeanor in I believe it was the Eastern District of Virginia, but I don't see a huge difference between that case and the general's case. And so why is Mr. Bolton being treated with such not kid gloves and with such seriousness and severity? And that raises questions about perception.
Yeah, no, I agree with you. So, it could be a meritorious case, but once again, the process just seems a little bit suspect. But let me just ask you from a high level, do you see this as winning? So with these three indictments, win for Donald Trump?
I think you have to define what winning is. If winning is the social media blast of these guys are criminals and we've gotten it right from the beginning, then yeah, it's clearly a win. If you're talking about it in the traditional sense of, is this doing right by the system and by the process, and will it result in convictions? No, I don't. I think time will tell. And obviously, this is the reason you have trials, the crucible of public trials. But I don't think this will yield success for the department. Time will tell.
All right, well, let's move on quickly to another topic, which also is being hailed as a win for President Trump, and that's the litigation surrounding his use of the National Guard to quell what he has described as rebellious activity against his ICE operations in various cities. Now, I'm just going to say at the outset, if you notice, if you're a legal nerd like we are, and you've actually read a lot of the briefing, the courts haven't really wanted to weigh in on whether this is a rebellion. And I always say, guys, this is not a rebellion. Like, this is human beings, American citizens, exercising their First Amendment rights to protest. Like, this is, it's not a rebellion. A rebellion is like, and we can get the dictionary definition, but it's essentially wanting to overthrow the government. People are just upset at Donald Trump's immigration policy. But what we are seeing is in a lot of cities across the nation that have this increased ICE activity, people are protesting, and some of those protests have turned violent. Now, it's the level of violence that is at the center of these disputes. Is the violence so out of control that local law enforcement is unable to quell it? But I think we have to recognize, because I hear some narratives that, it's all peaceful protest, just people holding up signs. Sometimes, but sometimes it's not. And that is the center of the controversy. Now, interestingly, the president is only targeting these types of activities in cities that are controlled by Democrats, in states that are governed by Democrats. But in any event, what he's done in Portland, Oregon, and now in Chicago, Illinois, is he's tried to call up the National Guard. We saw this in Los Angeles earlier this year. And he's saying, he's using the statute 12406, and he's saying, I have the right as the president to make the determination that things are so out of control on the ground that local law enforcement can't handle it. So I'm sending the National Guard in to protect federal facilities and personnel. So that'd be like your ICE facilities and ICE personnel. They're not operating as law enforcement officers, but they're there as a layer of protection because things are so out of control. Now, of course, these cities have been like, no, we don't want this. Usually it has to be on consent of the governor, request of the governor. These governors are saying no. You have Pritzker, who said absolutely no. The Trump administration has done it anyway, so the cities have gone to court and sued. And just recently, Oregon lost, where essentially the Ninth Circuit, that is the appeals court for Oregon and also for California, they said that they were bound by their decision in Newsom, which was the case coming out of California, where they also ruled in Trump's favor. And they said, you know what? We believe that the president has a lot of discretion here, and he can determine whether or not there's like three, they call it factual predicates, preconditions. One of three things has to be true for him to invoke this statute. And we think that as long as he has a colorable basis for making that determination, he can do that. Tell me your opinion, because Trump has won. This is now the second case he's won. And even in the Seventh Circuit, I just have to say, with Chicago, even though it looks like he lost because he's not allowed to deploy the troops, the appeals court actually agrees with how the Ninth Circuit analyzed it. They just said the facts don't support it at all. There's no colorable basis right now. So sorry to interrupt you. Go.
I actually don't think we're that far apart. So we're on an agree to agree train for a while.
Oh, that's good. I like that train.
Yeah. So here's the concern, right? To go back to something you said, that it feels wrong. It feels wrong because it is wrong, and it is not a legal issue. I actually agree with you that though I can quibble with some of the legal rationale of any court, that's what we do as advocates sometimes. The statute itself that you're referring to, which deals with the deployment of National Guard in emergencies, is a fairly broadly written statute, and there is a lot of pushback as a policy matter and whether that's the right thing to do. But as a matter of law, it would be fair to say, whether you agree with the Seventh Circuit or the Ninth Circuit or one of the district court judges, you are in sort of this weird world where the statute and Congress delegated that authority in a pretty broad way. One of the things that I think the last few months have taught, at least me, is that the rule of law is largely underpinned not simply by a statute that you follow, but it is by the norms that you follow as well. And the reason I go back to saying that this is wrong is not because I think that it was all peaceful. I agree with you. There were aspects of this, and frankly, I spent years prosecuting a case out of the US Capitol where a protest that was a First Amendment assembly sort of exploded into a violent riot. And so there are lines that get crossed, and when those lines are crossed, law enforcement should be able to pursue those accordingly. The problem is the facts don't match the rhetoric. If you're going to say that there is a rebellion, if you're going to say that an ICE officer was attacked, if you're going to say that, the station can't function and we can't process some of these things anymore, these inmates coming in and out, then there has to be sort of a factual basis to support that. And the tension that you are describing is not really the scope of the statute, how broad the statute is. It's how much can a judge opine and second guess what the department has said to the court in the four corners of the piece of paper. And this gets to a much larger issue that I'm sure we don't have time for, which is what we call the presumption of regularity. DOJ or many governments are presumed that what they are saying is being said in good faith. It's being said with a colorable fact on the ground. And judges from both sides of the political spectrum, appointed by President Trump himself, are saying, wait a second, hold up. That's just not true. And that tension that we're seeing sort of, the Ninth Circuit's opinion, the 2-to-1 decision between two presidentially appointed by President Trump judges, and I believe a Clinton appointee, which again, it shouldn't matter who you're appointed by. What should matter is your evaluation of the law. There's this massive tension about basically the dissent calling out what I would say is BS on some of the administration's claims as to what's happening on the ground in Portland. What we are seeing is law enforcement, local law enforcement, who know their cities and know their streets and know how to manage their populations when things get out of control, are saying, we don't want this. This is not helpful. And so, I actually understand the need to protect the agents and the officers in this process, but it needs to be calibrated with sort of the facts on the ground and what's actually happening. I mean, can you imagine if during a president, and I'm not stealing from President Obama because I think he said this, but can you imagine if President Obama brought National Guardsmen in from another state to Tallahassee, Florida, a sort of discernibly red state, and it was because there was a fight on the corner between, two drug dealers and we need to lock it down? I mean, the world would go apoplectic. I mean, the guy wore a tan suit and we lost our minds. So
We went crazy. Yeah.
I just think it's important to be able to sort of step back and not do whataboutism, but the gut feeling that you're having seems legitimate because you are questioning the predication for why we're in this situation in the first place.
So finally, we're coming to the end, and I so appreciate you parsing all this out with me because it is super complicated. The last one is new reporting. Donald Trump is seeking $230 million from his own Justice Department. His claim, it's through an administrative process, and his claim is essentially malicious prosecution for the investigations and later indictments for the classified documents case out of Mar-a-Lago and, of course, the Jan 6 prosecution. I said that, when I heard this, first of all, I thought it was a fake headline. Swear to you, I said this on TV this morning, I did not think it was a real headline. When I clicked and realized it was a real headline, I just imagined Trump, and this is dating myself, right? But like the 90s Michael Myers, Austin Powers, he was Dr. Evil with the cat, like $230 million from my department to be paid to me, and to be clear, yes, exactly, with the cat, that's what I see now in the Oval Office. Because what? This is his department, just to make clear to people who are listening, this is, as Donald Trump is now exercising more control over a department that has been traditionally independent than ever, unprecedented amount of control and influence in this department. The department is run by his former lawyers. Like, the person who would have to sign off on this payment is Todd Blanche, who represented Donald Trump in his hush money case in New York and was also representing him in the January 6th, I think the Mar-a-Lago too. So conflict of interest there. And also he would be taking the money for himself. So it's like he'd be taking taxpayer money through his own department to pay himself. Am I missing something?
No, I don't think you're missing anything. And
Okay.
I don't have a lot of words for it. I mean, you know, one narrative that I think comes out of this for me is like, this is quintessential self-dealing. And, you know, what constitutes, as you know, a malicious prosecution, there's actually a legal definition for this, and there's a bar that must be met. And you can critique the January 6th or the Mar-a-Lago prosecution all you want as to whether it was politically motivated or whether or not it was politically wise to pursue. But I mean, it withstood, you know, the crucible on a number of levels, not just the grand jury, which is something we talked about earlier, but on some of the briefings and some of the legal issues that came up throughout that litigation. I think it's a hard argument. I think it's a pretty silly argument to say that, you know, these cases rise to any such level. I also think it creates, and I'm not sure if people are thinking about this, it creates an incredibly perverse incentive for the government to never investigate a political actor. Because if you investigate a political actor and that person ends up working in connection with the United States government or becoming president of the United States or becoming some high-level executive within the government,
although I would hope a lot of folks who are under criminal investigation don't ascend to those offices, but go ahead. But I hear what you're saying.
Yeah, but then you just demand money back. I mean, from the American taxpayers. I mean, it sort of disincentivizes prosecutors and investigators to actually look at crimes as opposed to people.
Thank you so much, Greg, for joining me to explain all of this. I hope it helped folks understand, because again, these are very complicated issues, but just distilling them down, it is very consequential to the rule of law, and we need to continue to have these conversations and bring it to the forefront. So thank you so much for joining. For everyone who's enjoyed this conversation, be sure to click like, subscribe, and to tell folks, at least you heard it here.